Hello everyone, I am Ardiansyah, lecturer in IBLAM School of Law, Jakarta, Indonesia. And I'm also customs specialist in Indonesian Customs Excise. Welcome to today's presentation. Today, I would like to present my research entitled Burden of Proof of Custom Valuation Dispute in Indonesian Tax Courts. Today, we delve into a critical aspect of tax law, the burden of proof in customs valuation disputes within the Indonesian tax courts. Our focus lies at the intersection of legal interpretation, comparative approaches, and practical implications. So the background comes from custom valuation disputes, where the dispute arises when the importers and customs administration disagree on the valuation of goods for tax purpose and also for customs duty purposes. The stakes are high, affecting the revenue collection and trade facilitation. And then the dispute comes to the tax court's jurisdictions based on Article 95 of Indonesian Customs Law, grants individual the rights to appeal decision made by the Director General of Customs Excise to the tax courts. Within 6 days, party can seek redress through this specialized judicial body. So the problem arises in this research regarding burden of proof. The define of the burden of proof, it refers to the responsibility of presenting evidence to support a claim. In custom valuation dispute, who bears the burdens become pivotal. And the focus in this research is about the different interpretation, where some judges place the burden on importer while other assigned to the customs administration. So this is inconsistency reflect to legal predictability. Then scope and research question. So the scope for this paper revolves around the implementation of the burden of proof in tax law and customs law, particularly regarding custom valuation. And then the position of judge in tax courts to place the burden of proof for settling custom valuation dispute. So the research questions are as follows. The first one, how the burden of proof applies in tax law. The second, how custom law regulates the burden of proof based on WTO law and Indonesian customs law. And the last, why there is a difference in applying burden of proof among the judge in the Indonesian tax courts. Research methodology. This is the legal research and carried out with 3 approaches. The first, comparative law or comparative legal approach to explore how the other legal system handle the burden of proof. And in this research, we use a European legal system. And statute approach is to examine how custom law regulates the burden of proof, considering WTO law and Indonesian custom law. And the last approach, case approach, on court's decision to find out the reason from each party to the dispute and consideration of the judge based on the tax decision. So the result of my research, the first, it's concluded that the provision of reversal of burden of proof or shifting of burden of proof to a company of taxpayer are adopted both in tax law and custom law. This provision are applied if the company or taxpayers cannot complete the evidence and document required by tax administration. And the provision of reversing the burden of proof are also stated in WTO valuation agreement, namely in Article 19 and WTO Ministerial Decision number 6.1, which has been ratified by Law number 7 of 1994, concerning ratification of the WTO in Indonesian legal system. Furthermore, based on my research, custom law is still unclear to regulate the reversal burden of proof for custom valuation. So, as a result, the difference in applying the burden of proof among the judges is caused also by tax court procedural law, which applies freedom of proof doctrine in the settlement of tax disputes. Okay. Thank you for your attention. And this is my context. Download links and credits. You can cite my article. And also my article is collaboration with Mr. Suganda. He is associate professor in University of Jayabaya. And this is the link. You can download the PDF file from this link. And if you have a further question, you can contact me in email, ardiansyah@iblam.ac.id. Credit for University Utara Malaysia that held International Law Conference in 2019. And also International Journal of Law, Government and Communication. Thank you very much for your attention. I invite any question or discussion, and let us continue our pursuit of legal certainty and justice in the custom valuation. Thank you very much. Goodbye.